Intoxication assault. What is it? What does the state of Texas have to prove? Is there a way that you can defend the charge? Hi, I'm Jeff Hampton with the Hampton Law Firm. Today I want to break down the offense of intoxication assault in Texas. I want to give you a few things to think about. What does the state of Texas have to prove? Are there some defenses available if you or a loved one has been charged with this crime? By the way, if you wait around to the end of this video, I'll also give you a free ebook, Your Ultimate Guide to DWI Defense in Texas. Okay, now, first and foremost, if you or a loved one have been arrested for intoxication assault in the Texas area, the first thing I always want to remind people is you have 15 days from the date of your arrest to request a license hearing. You see DWI cases, which intoxication assault falls underneath that category. Every DWI-related offense, you break down the case into two parts. The first part is your driver's license. The second part is the criminal case itself. Well, on the driver's license side, you have 15 days from the date of your arrest to request an administrative license revocation hearing. If you fail to make that request within 15 days, your license will automatically be suspended 40 days after the date of your arrest. So it's important. Don't miss that. Mark that down on your calendar. Now look, most people can't imagine a situation worse than driving a car that's involved in a car accident where someone else gets injured in some way. And the idea of this is bad enough, but then if this sort of issue arises and now police get involved, there you end up having a situation where you could be charged with a felony crime of intoxication assault. So one of the things we're going to look at here, because there's so much at stake, let's first define what Texas law says about the crime. Under Texas Penal Code Section 49.07, you can face intoxication assault charges if you're responsible purposefully or accidentally for serious injury that occurs to another person if you're operating a motor vehicle, watercraft, aircraft, while intoxicated. Now, here's the thing. What do we mean by that? Well, when we talk about while intoxicated, that one element right there is basically we break down DWI law. So in addition to those other elements that I just mentioned, where someone is seriously injured and you're operating one of those types of vehicles, we're now looking at what are the elements of DWI that apply to intoxication assault. Well, the state of Texas is going to have to prove that you or your loved one were operating a vehicle while in Tarrant County or a county in Texas, depending on what county you're in a public place while intoxicated. So intoxication is specifically defined under Texas law as lacking the normal use of your mental, number one, or physical, number two, faculties by reason of the introduction of alcohol, drugs, or dangerous drugs into the body, or number three, having an alcohol concentration of 0.08 or higher at the time of operating that vehicle. Now, the failure by the state of Texas to prove each and every one of these elements of the crime should result in a not guilty verdict. And we'll talk a little bit more of that here in just a minute, okay? But there's two main important factors that one of the big factors that we're going to look at here that distinguishes intoxication assault. Number one is the definition of serious bodily injury. Now, we talked about if you have a DWI and someone's serious bodily injury as a result of that, you're now moving from a Class B misdemeanor, you're elevating yourself up to a pretty serious felony charge. So let's define what serious bodily injury is. Serious bodily injury is defined as an injury that creates a substantial risk of death or that causes serious and permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ, okay? So we're gonna look at serious bodily injury and then we're gonna spend some time talking about causation, two of the biggest areas that are involved with intoxication assault. Now, before I get into that though, let's talk about punishment. What type of felony are we looking at and what are the types of consequences someone can face for this offense? Well, under Texas law, intoxication assault is considered a third-degree felony, and if one is found guilty of this offense under the Texas Penal Code, you can face up to a prison sentence of 10 years in prison and up to a $10,000 fine. Now, It doesn't mean that you are going to go to prison, but we're just talking about that's the type of level this is. It is a third-degree felony. There can be many other types of consequences as a result of this. If someone is convicted of this type of offense, it can result in losing your gun rights, your right to vote. There's many other things that'll permanently will affect employment opportunities in the future. So it's really important that you fight this case. Now, what does the state of Texas, through the prosecutor's office, have to prove here on an intoxication assault offense? This is one of the areas we're going to spend some time on. One of the big areas that they have to prove that comes up all the time is the element of causation. The element of causation must be proven beyond a reasonable doubt by the prosecution. Now, at first glance, that seems simple. But in reality, sometimes the element of causation can actually be kind of complex. For example, if you've been involved in a two-person accident and the passenger in the other vehicle was seriously injured, you may think that the police will automatically assess the fault for those injuries to you. However, there could be many other factors that could play into whether or not they can actually show causation, because here's the key. They have to prove that the intoxication was the cause of the injury. That's what have to be proven. So let me give you some examples. What if the other driver was at fault? What if the police accident reports indicate that the other driver was partially or entirely at fault for the accident? For example, what if the other driver ran a red light, and as a result of running that red light, you end up hitting that vehicle? Now, maybe you were intoxicated at the time, but were you the actual cause of that injury? Even if you were intoxicated at the time of the accident, you may not have been the cause of the injury. Your intoxication may not have been the cause of that injury because of that superseding cause of the other driver being at fault. All right? Now, if the passenger in your vehicle or another vehicle was injured in an accident caused by you, but what if the passenger was injured and they failed to wear a seatbelt? Okay? What if there was partial causation caused by the passenger? Now, I'm giving you this as an example just to be aware of it. While the accident may have been your fault, if the passenger was not wearing a seatbelt and the injury was caused based upon that and not tied to your specific intoxication, that provides you a defense. I want you to understand, causation is not just as simple as it may appear to be. The state of Texas must tie in your intoxication to the cause of the injury, okay? It must be approximately tied together, all right? The reasons for these defenses for intoxication assault can prove effective is from the section of Texas Penal Code section 6.04a, talking about causation. Let me read this to you. A person is criminally responsible if the result would not have occurred, listen to this, would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. So as you can see here, intoxication must be proven by the prosecutor to be the cause of that serious bodily injury, okay? Now, I wanted to spend some time on that because I want to make it crystal clear how important that is. Now, another way to defend these charges is to question the results of the field sobriety testing. Now, if you were investigated for a DWI or intoxication assault, there's a good chance, unless you were seriously injured yourself, that police officer asked you to do some field sobriety tests. And I've covered this in many other videos that I've put out before, but remember, very quickly, I want to remind you, field sobriety tests are only as reliable as the officer following the guidelines for administration for testing. The National Highway and Traffic and Safety Administration has said very clearly that if the police officer does not administer the field sobriety test properly or follow the guidelines, they are deemed to be unreliable and should not be relied upon to determine someone's possible intoxication. Okay. Now, what about blood tests in intoxication assault? One of the most important pieces of evidence an experienced and an aggressive intoxication assault attorney will review and challenge are the blood results. This can be very important because frequently there may be problems that arise with blood testing and the administration of that blood testing. For example, was the person taking the blood a qualified technician as required under Texas law? Did the technician use an alcohol or betadine swab in the process of taking that? Were the blood vials sealed properly, or was there spoilage because they were not sealed properly? All of these are things that must be examined. And even if there was a blood draw that was done properly, think about this. What if the blood draw was done many hours after the fact? Remember, the prosecutor must prove beyond a reasonable doubt that you were intoxicated at the time of driving, not 4 or 5 hours later when you may have taken a blood draw, okay? That is critical to remember. Now, a blood test merely shows what your blood alcohol level was at the time you gave the test, not when you were driving. So the state of Texas will try to extrapolate back in time, and if they are not able to do that because you didn't answer certain interview questions and because maybe their evidence that they gathered was not sufficient to go back and extrapolate, then there could be reasonable doubt established regarding your intoxication. Finally, let's talk about grand jury. If any of these legal defenses, maybe causation, maybe there's some issues with the blood testing, or maybe the field sobriety testing. Let's say some of these issues arise in your case or your loved one's case. If that's the case, your DWI attorney should be very aggressive with the grand jury. The grand jury is a panel of citizens, and Texas law provides that every single felony case must be presented to a grand jury for indictment. So if it turns out you have a valid defense, it is clear, it's very important. It's very important that your attorney make that presentation to the grand jury early, because the grand jury could do one of three things. Let's say they could, number one, keep it as an intoxication assault. But what if you weren't the cause of that injury? They could now drop that intoxication assault down to a misdemeanor DWI. You could be talking about dropping a third-degree felony down to a Class B misdemeanor under those circumstances, and it's a lot easier to fight that misdemeanor than it is a felony. Or finally, what if they're not able to prove intoxication as well? You could now be talking about what's called a no bill. A no bill is a complete exoneration of the charges, and it would then provide you eligibility after the statute of limitations period has lapsed. You will then be eligible to have the entire arrest and charge expunged from your criminal record. Now look, there's a lot here to go over, okay? So I can't cover everything in a single video, but if you are facing an intoxication assault charge in the North Texas area, I want to invite you to have a free consultation and case analysis at the Hampton law firm. Now, feel free to give us a call. You've seen this number right above you, above my head the whole time I've been talking. Don't hesitate to give us a call. Ask for a free consultation. If your case is in the North Texas area, we'll break it down for you and see if we can help you, okay? Thank you for joining us here today. Remember, I offered you a free ebook. If you'll click on the link down below in the YouTube video, I'll send you a free ebook, The Ultimate Guide to Your DWI Defense in Texas. I want to thank you for joining us here today. We'll see you next time.